Presentation will come here, right?
Huh?
Presentation will be in the.
Oh, okay. Can you give this to the speaker, to the lawyer?
Okay.
Put it here.
So you will send the link.
Inshallah, yeah.
Okay. Okay. Oh,
I have never. Is this safe? It's not going to blow up, is it?
it's safe.
Like a pager.
Yes.
Are we ready?
Usually.
Just let me know.
Do you mind actually if I take the Mahmoud? He's gonna do Quran recitation first, so we should put it on him first.
I have another one.
Okay, Bismillah. Jazakallah khair.
They told me they're going to record it. Now I'm real nervous. I think I must be perfect, but I must let Allah's will be done. I'm surprised there are this many people here. I'm honored.
Four times more. You know, they should have come, you know, and to this important issue.
Well, we
Where do you know?
can hopefully continue the learning process together. So if there's topics that we want to pursue
I will
further.
scan this information as well and give it to
Thank you.
the website.
Thank you. But
Or if you want something else.
what's going to happen is, but we can give this out, but after today, I'm going to learn so much that I'm going to want to add to this.
All right. Okay.
So it'll be I'm going to grow this into a book. Because there's so many topics and there's so little knowledge, especially in America. And I'm the first to admit that.
So these wills also affect you. The properties from the probate in case of your death or not really the wills.
Are you talking about like keeping wills in trust for grandchildren or children?
Children, for example. I understand that if you've got a trust, then they won't have to go through probate.
Right.
But if you have just a will that also save
Yeah.
them from going through?
If you just have a will, it has to
No,
go
no,
to probate.
It has to go to probate. Okay.
Assalamu alaikum.
Alaikum salam.
On the sister side, please make sure the projector is down. And if the sisters would like to also raise the blinds or look in the screen, so you can be a part of the program, inshallah. The lights are on the brother's side, so it's a reflective glass, reflective window. So you can raise the blinds, you can lower the projector. We are projecting a screen, and make sure the TV screen is on, inshallah. Bismillah ar-Rahman ar-Rahim, alhamdulillahi rabbil alameen, wassalatu wassalamu ala rasulil ameen, wa ala alihi wa ashabihi ajma'een. We start off by praising Allah subhanahu wa ta'ala. May Allah subhanahu wa ta'ala send his peace and blessings upon our messenger, alayhi salatu wassalam. And we will start off with a recitation of the Quran by our dear Imam Muhammad from Surah An-Nisa, inshallah.
Cookie.
أعوذ بالله من الشيطان الرجيم. للرجال نصيب مما ترك الوالدان والأقربون وللنساء نصيب مما ترك الوالدان والأقربون مما قل منه أو كثر نصيبا مفروضا. وإذا حضر القسمة أولو القربى واليتامى والمساكين فارزقوهم منه وقولوا لهم قولا معروفا. وليخشى الذين لو تركوا من خلفهم ذرية ضعافا خافوا عليهم فليتقوا الله وليقولوا قولا سديدا. إن الذين يأكلون أموال اليتامى ظلما إنما يأكلون في بطونهم نارا وسيصلون سعيرا. يوصيكم الله في أولادكم للذكر مثل حظ الأنثيين. فإن كن نساء فوق 2 فلهن ثلثا ما ترك، وإن كانت واحدة فلها النصف، ولأبويه لكل واحد منهما السدس مما ترك إن كان له ولد، فإن لم يكن له ولد وورثه أبواه فلأمه الثلث، فإن كان له إخوة فلأمه السدس من بعد وصية يوصي بها أو دين. آباؤكم وأبناؤكم لا تدرون أيهم أقرب لكم نفعا، فريضة من الله، إن الله كان عليما حكيما. ولكم نصف ما ترك أزواجكم إن لم يكن لهن ولد، فإن كان لهن ولد فلكم الربع مما تركن من بعد وصية يوصين بها أو دين، ولهن الربع مما تركتم إن لم يكن لكم ولد، فإن كان لكم ولد فلهن الثمن مما تركتم من بعد وصية توصون بها أو دين. وإن كان رجل يورث كلالة أو امرأة وله أخ أو أخت فلكل واحد منهما السدس، فإن كانوا أكثر من ذلك فهم شركاء في الثلث، فإن كانوا أكثر من ذلك فهم شركاء في الثلث من بعد وصية يوصى بها أو دين غير مضار وصية من الله والله عليم حليم تلك حدود الله ومن يطع الله ورسوله يدخله جنات تجري من تحتها الأنهار خالدين فيها وذلك الفوز العظيم ومن يعص الله ورسوله ويتعد حدوده يدخله نارا خالدا فيها وله عذاب مهين. تكبير تكبير تكبير. Jazakallah khairan, Imam Muhammad. Now we will have our dear brother Tahir. Tahir Bhai will now do a reminder as well as some translations of the verses, inshallah.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم. We recited verses from Surah An-Nisa, verse 7 to 14. These are the verses which describe today's program. These are the verses regarding Wasiyah. So we will go over the translation. For men, it is the share of what the parents and close relatives leave. And for women, it is a share of what the parents and close relatives leave, be it minor or much, an obligatory share. And when other relatives and orphans and people in need are present at the time of division, then provide for them something out of it, that is from the estate, and speak to them words of appropriate kindness. And let those, that is executors and guardians, fear injustice, as if they themselves had left weak offspring behind and feared for them. So let them fear Allah and speak words of appropriate justice. Indeed, those who devour the property of orphans unjustly are only consuming into their bellies fire, and they will be burnt in hellfire. Allah instruct you concerning your children, that is their portion of inheritance. For the male, what is equal to the share of two females. But if there are only daughters, two or more, for them is 2/3 of one's estate, literally that which he left. And if there is only one, for her is half. And for one's parents, to each of them is 1/6 of his estate, if he left children. But if he had no children, then the parents alone inherit from him. Then for his mother is 1/3. And if he has brothers and or sisters, for his mother is 1/6, although the siblings themselves do not inherit in this case. After any bequest, or he may have made a death, your parents and your children, you know not, which of them are nearest to you in benefit. These shares are an obligation imposed by Allah. Indeed, Allah is ever knowing and wise. And for you is half of what your wives leave. And if they have no child, but if they have a child, for you is 1/4 of what they leave. After any bequest you may have made or debt. And if a man or woman leaves neither ascendants nor descendants, but has a brother or a sister, then for each one is a sixth. But if they are more than two, they share a third. These shares are divided equally between males and females after any bequest which was made or debt, as long as there is no detriment caused. This is a condition for any bequest if it has been violated by the deceased or bequest is not to be honored, or it may be adjusted by the executor. This is an ordinance from Allah, and Allah is knowing and forbearing. These are the limits of Allah, and whosoever obeys Allah and His Messenger will be admitted by Him to gardens in paradise, under which rivers flow, abiding eternally there. And that is the great attainment. And whosoever disobeys Allah and His Messenger and transgresses His limits, sallallahu alaihi wasallam, He will put him into the fire to abide eternally there, and he will have a humiliating punishment. So, my dear respected brothers, Jazakumullah for showing up. Allah allimna bima allamtana wa yanfa'na bima allamtana. Allahumma allimna Allahumma la ilma lana illa ma allamtana innaka antal alimul hakim. So we welcome Rex Hodges. I have worked with him in the past 1 year. He is an attorney, state attorney, and at the same time he spent few years back in 2004, 2005, 6 in Iraq through the State Department, helping the State Department as a translator, and so he has a lot of interaction with Muslims over there. So he knows, mashallah, lot of things in Islam. I learned few things from him. And by the way, these verses and some of the these he sent us. That's so you know his knowledge. He sent some parts of these verses and these to us regarding Wasiyah. Also, I want to remind you that he is, an attorney, and the question that you ask him should be related to the laws of this country regarding state planning, and all those things. He is not a Muslim scholar to give some religious, verdicts or more information. So for that, we will have, inshallah, next week, hopefully next Friday, another lecture from a scholar, and we will go in detail. Right now, what we know is that a man inherits twice as much as a woman, but that's not the case. In certain cases, a girl will inherit twice as much as his brother. So it gets complicated, more and more complicated. And majority of us do not know those things. So inshallah ta'ala, we will continue next week on those details. So I will invite Rex to go over the, his presentation, and then we have plenty of time. I encourage all of you, my dear brothers and my dear sisters, to ask related questions. That's why we are here. Jazakumullah khair.
I'll just sit down
You'll sit
Permit me
down.
to grab my water real quick.
We have water for you. We
Oh, you
have
do?
water.
Thank you. Are you ready for me?
Yes.
Yeah, you would like to have a seat?
Yes.
Okay. ताहिर भाई, इसको खींच सकते हैं? जी।
Already tired.
Pardon me?
You look already tired. You need
I was
water.
up, I was up all night thinking about this.
Water for you.
Thank you.
Mhm. Have a seat.
Thank you.
So ladies are in that side, men's are here. So there are plenty of ladies, probably more ladies than men.
Okay, I appreciate it. Assalamu alaikum. May it be pleasing to Allah. So, Brother Nasser mentioned I was in Iraq a couple of years as a deputy senior advisor to the Iraqi Ministry of Transportation.
Women's
you-
can-
Is it working?
इसको मैंने ऊपर कर दिया था।
Okay, normally secret sections to have- Table move करना? Then let's move the table a little bit, wait, and let's see you, I think.
Okay. Well,
Little bit.
they probably don't want to.
No.
Oh,
And then
you want me to sit over here?
Yeah.
Okay.
yeah, the camera should be there. Can you ask the women?
More right.
More to the right?
This way? This way.
Oh, okay, thank you.
Okay. Can you see Sheikh Muhammad? Yeah, but right.
Let's over there. Because they see this projector.
That's good. That's good.
Yeah.
That's good.
Okay, thank you, Imam. Can you hear me? Is this working?
Yeah.
Are we good?
Yeah.
Salam alaikum again. I was mentioning I was deputy senior advisor for the U.S. Department of Defense and the U.S. Department of State in the reconstruction of Iraq. I was working with the Ministry of Transportation, rebuilding the ports down in Qasr and the airports and roads and bridges. But I had the honor and privileges of working directly every day with Iraqi port officials and airport officials, and developed a keen appreciation for Islam and the culture. And I still, to this day, dream of going and spending some time with the Bedouins in the desert in Kuwait or Iraq. The peace that they seem to have is what I'm reaching for. But basically, that's where I got my interest in Islamic law. And when I got back, my history was in trusts and estates and contracts, and I have Islamic friends here, and we were talking about the differences between Western and Islamic law. And so I got interested in the estates and the trusts. And I read the Quran a few times. I'm a novice. All of you know many more times than me about the Quran. So I learn more from you than you learn from me. But what I'm trying to do is be sure that the trusts and wills are in compliance first with Sharia, second in compliance with your intentions, and third, but equally as important, that they would comply with Oklahoma law or Texas law or wherever you happen to be residing, because those are going to be the laws that govern it, because we get to have judges that are elected. And so the idea is to avoid the probate that a will normally goes through, because a court has to determine if a will is valid before it will be enforceable. And that causes you to have to file a probate with the county court. And that sounds easy, except all of a sudden, all of your estate becomes public record, because anybody that wants to contest your will can do that. Or if they say, no, he said he was going to leave me this or that, they can contest it. So the probate court has to issue and publish a notice that your will is being probated, and that gives anybody that wants to claim, including creditors like hospital bills, a chance to file their claims with the estate. So that's a good thing. However, it's to be avoided if you can, because you don't want the publicity, one. You don't want the expense of having the probate, two, if you can avoid it. And three, you don't want to have to go to court. And sometimes I've seen probates last for more than 10 years. There was a very wealthy family in Oklahoma City. His name was Goldman. And he was one of the richest men in Oklahoma for a long time. But his estate was settled and he had two sons. Well, it was. I don't even know if it's settled yet, but I followed it for 10 years. And the two sons were fighting and bickering. And the probate went on for 10 years. So the idea is to make it as clear as possible that it complies with your intent. Now, the Imam at the beginning mentioned, and I think it might have been in the reading, that it is required by the Quran or Sharia to have a will. And I think that is a little bit frightening. I mean, if I was looking at it as a requirement, I would want to get it done. However, that phrase of getting it done now is somewhat intimidating, because you go, oh, I got to get everything in order, and I got to get the money, and I got to make an appointment, I got to go see a lawyer. And so people, I think 50% of Americans do not have wills, and that applies to lawyers because they just don't get around to it. And there's no reason for a Muslim not to get around to it, because I believe the Sharia is much preferable to Oklahoma statutes or any Western statutes, because the Sharia defines specifically how your estate is going to be distributed to your family members, your children. And there's nothing really for you to decide unless you want to give specific gifts to specific people or have specific provisions for special needs. But anyone can go home right now and write on a piece of paper in their own handwriting. They can even write it in Urdu or Arabic. This is my last will and testament. I, John Doe, hereby declare this is my last will and testament. It doesn't have to be in this formal language. Just write it down in your handwriting. It's very important that this be in your own handwriting, because if you start typing it or word processing it, then you get into the formalities of having to have two witnesses and a notary. And you don't need to do all that. And they developed this, it's called a holographic will, okay? And it's legal in most states. Holographic means it's in your own handwriting. And they developed this for soldiers in foxholes when they're about to die, and they don't have a will, and they've got to write it down real quick, and they're in a foxhole and they can't get the lawyer. So they write it, they provided you can write it down in your own handwriting and then just sign it, and that is enforceable. But I would suggest, if you can't get into the details, you don't know who's going to get that, I still got to decide who's going to get what, and just write down, I desire that my estate be distributed in accordance with Sharia. And then appoint a personal representative, a trusted individual, to oversee it, so they'll know who to take directions from. That's all that's really needed. And then your own hand signature and a date. And that is your will, in my opinion, would comply with your obligation to Sharia. It's not going to set forth the details. It's not going to have all the special gifts that you want. And you can do that yourself too. If you say, I desire that my sister get my house in Pakistan or whatever, and that you can spell that as long as it's in your own handwriting. You start using the typewriter, and then you got to do the execution. And I'm not saying do that. I prefer that you go into detail and have it all planned out as far as specific distributions. But don't put off doing your will until you get all that sorted out. Because once you do a will, it's easy to change. You can change it every day if you want to, but a lot of people change it at least every year or two as they have family members pass away or if they have special needs. But so I prepared this outline, and Mr. Nasser suggested or offered that I might make a PowerPoint. And I've done a PowerPoint one time before in my life, and I had this slide up there. And I had, I don't know, 10 or 20 slides, but I found at the end of the presentation, I was still on the first slide because I didn't pay attention to the PowerPoint. So that's what I was just doing. When I was driving here, I thought, look at my outline, and I thought, I need to talk about that holographic will. So I get off on tangents here, so you need to keep me on track. But I wanted to be sure everybody covers that base of having their will provided. On the outline, I don't know if you're following along, but on Roman numeral 1, why estate planning matters, I think it's been covered that everybody knows about the Islamic requirements. And one thing that I want to expand on, and I find this is an issue, and it's always been kind of an issue to me, and I still want to learn more about it. So your input is very important. But on number one, down under number three, it says distribute your estate, and this is what the will do, provide that you distribute your estate in accordance with Sharia. Now, in my novice reading of the Quran, it requires percentages or shares to go to different heirs. And one thing I've got to learn a lot about is the culture of the Middle East, and especially back in the days of the Prophet, peace be upon him. But I can imagine that most of the assets then were agricultural, farmland, possibly camels, livestock. But it would have been, I think, easy to divide those kind of assets because they're fungible, and you can divide that. You get a third of this farm, you get a third, and everybody's happy they got their percentage. However, what if you have a peach farm and a horse farm, and then you have two children, and then you've got to divide it equally? But one of the children wants the peach farm and one wants the horse farm. I think as long as the values are in proportion to the Sharia, that you can specify which assets go to which individuals. And so that has to do with the distribution, and that's something that I would like clarification and support for, because that's what I've suggested. And there's some other things that I have suggested, and I may be completely off base, and if anybody finds it offensive, please let me know, because I do not want to be offensive to Sharia. I don't have any business doing that. So if you can specify who gets it now, and then you get more into that, because you say, well, my daughter's going to get the peach farm, but she doesn't necessarily know how to manage it. So you can appoint a trustee, or you can place that peach farm in a trust to be for the benefit of your daughter for her life, and you can appoint who's going to run that peach farm, and that takes the burden off of her. But those are extra branches of the tree you can go out on. And we'll talk about present value. Usufruct, is that the word where you can have a present value in the interest now? For example, I could give my brother next year's rental income from the cotton farm, and my mother the income from the year after that. In other words, each period of time that you own the property has a value. And I think the word is usufruct, the Arabic word usufruct. Does that ring a bell? I apologize. I made it a point to remember it, which means I forgot it. But there's what we were talking about, the daughter having the property for a year and then it going to your mother. You can give through your will that 1 year interest in the property, and then give another year interest in the property to someone else. And I believe that's called, if somebody would help me with that word, I'm sure I've got it all wrong. But those are some considerations, like you want your daughter to have it. She's taking care of her life, but after her life, maybe you have other intentions. So those can be done. It's way beyond the handwriting of the will that some people hopefully get started with. We want to avoid the probate. We talked about that. And I don't see that. There's another thing that I think is a difference between American or Western wills and contracts and life in general compared to the Middle East, and at least with regard to my experience in the Middle East and Iraq. And that is, the families in the Middle East are much closer than they are in America. In America, everybody's transient and people don't necessarily keep family connections. I mean, I talk to my sister once a year, and we don't have, in Iraq, the neighbors were a family, the family was a family. And I don't think in the Middle East, at least in the Islamic cultures, that there's the tendency to fight about everything and dispute everything, especially among family members, like happens in Western society, where if the family's gonna, if a father or mother dies and is leaving a big estate, the kids are all, oh, I want this, I want that, I want that. I think with the Islamic system that's set forth straightforward, that there's a lot less likely to dispute it. And I think that there's also a system in Islamic society that the family respects the others. There's going to be respect for that person's distribution in the will. and they're not going to be this contingency fights. But here we are in America, so there's an ability, if somebody wants to dispute your will, they can take it to court. But I don't think that's as likely in Islamic. And we'll get to this in a minute, but that has to do with the spousal shares. And we were talking about 2 shares, 1 share, and the shares that go to the wife versus the shares that go to the husband. And there's lots of reasons for that, and I've heard different reasons for it. But Oklahoma statute has a statute, and Texas has a similar statute that's called partition, but Oklahoma has a statute that provides for a forced share. So if, for example, somebody's mad at their spouse, so the wife does her will and says, I'm going to leave my husband nothing, okay? Happens. So the husband like, oh, I worked hard too, I should get half of what she has. And so Oklahoma legislatures, and I'm saying man or woman, it could go either way, but Oklahoma back in the day, they said, well, I think everybody split everything half and half, because so basically your estate will consist of, in accordance with Oklahoma law, if you inherited property before you were married, or you inherited property any time from your family, that remains separate property. If you acquire property together, that's joint property. So anything you came into the marriage with will remain separate if that's what your desire is, or you can have it become joint property where it gets divided equally. But back to the example, the husband is coming in and saying, I should get half. Well, Oklahoma statute said, well, it's not fair that spouse got left out of the will and he or she worked to earn those assets. So the forced share is 50-50. And if you don't put in the will, and this is a technicality, and I don't even think I've seen it happen, but I could see it happening, and I'm sure it has. The forced share, 50-50, if you don't put in the will that we waive that forced share, and instead we desire that it be distributed in accordance with Sharia, as we set forth in the trust also, then that spouse that got less than that forced 50-50 share can come in and contest it in an Oklahoma court. And the Oklahoma judge is likely going to say, well, since they didn't waive that, you must not have known about it. So since you didn't know about it, it should be 50-50. That's the risk you take if you don't waive that forced share. And I mentioned that in here, but I jumped ahead, so forgive me. So what if there is no will? We kind of talked about, no, we didn't. We talked about the probate versus the non-probate. But you also have a lot of people that don't even have a will. And what's going to happen then if there's a dispute over your assets, or if you have title to property, you're going to have to go to court, and one of the heirs is going to have to file a probate. It's called an intestate probate. And intestate means you don't have a written will, or you couldn't find it. And so then the court gets all their worries taken care of, because they get to distribute your assets in accordance with state statute, which is wildly different than Sharia. And I think Sharia is preferable, and it makes a lot more sense. So that's a reason to waive the forced share, and it's a reason to prepare the will so you don't have to go through the intestate process. Now, there's also a lot of people that have a lot of property that they don't have a will, and it doesn't go to probate because the family is tied, and they say we can take care of it ourselves. So a lot of estates are basically, they're able to handle it themselves, but I foresee in that situation problems arising, because if there's title to property involved, like real estate or cars or investments, then typically you would have to go to court to get the names on those titles changed into the beneficiary. And so that really doesn't help anything as far as avoiding probate. So basically, not having a will is probably the worst. Having that holographic covers your bases. And then you go into details as what we've been talking about. And I think that pretty well covers number 2. I think these are going to be distributed now this outline is kind of preliminary, because I know when I'm coming here and hopefully in the conversations and questions, I'll have lots of questions to pursue and hopefully expand upon this and clarify it. And that's why all of your input is so welcome, because like I say, I am learning. Down on number 3, benefits of a revocable will, of a revocable trust and a will. I think we kind of talked, I kind of jumped around, but we've kind of talked about a trust. Now, there's a revocable trust and an irrevocable trust. And what's the difference? Well, revocable means what it says. If you set up a revocable trust, which I recommend you do in connection with the will. Because if you have a revocable trust, you place your assets in the name of you as trustee of that revocable trust. And for estate purposes, that gets it out of your estate, so it does not need to be probated. So if you can put all of your assets in the name of your revocable trust, then there's no need for probate, because those assets are in the trust. There's no assets left to be distributed over here. Another way to, well, if I go into another way, I'll start jumping around again. But the revocable trust helps you avoid probate, okay? And it helps you avoid all that publicity that's going to go along with it, and the expense of having to go through court hearings to have the probate, the publicity and the expense and the headaches. So that's where that's the primary purpose of the revocable trust. And like the will, the revocable trust can be amended as your needs and as your intentions change, as your life conditions change. They can be changed. With computers these days, it's easy to make these changes. For example, you have another child, you have a child that has special needs, so you want to set up a specific trust for the child with special needs. You can always change the trust. If it's revocable, you can change it. Revocable means you can change it, means the assets are still in your name, technically for tax purposes, IRS, and that income from that revocable trust property flows through to your personal income tax return. So there's no need to even get an additional ID number. And that takes care of the probate. And then it takes care of the distributions. And in that trust, you can specify if you want another trust set up to take care of your grandchildren after you're gone, or the education of a certain child. You can set specific trusts or specific terms in your revocable trust that upon your death, those additional trusts or their assets for those specific individuals will be held in trust for their benefit in accordance with your directions. Does that make sense? Am I talking too fast? Got it going a little bit. And that brings me to how we're going to do this presentation, since we're just getting started. But I wanted to have it kind of conversational, because I'm sure there's lots of questions and there's lots of things that I need input on. And so I didn't know. It's just kind of whatever you feel like. If you want to talk about the question now, or if you want to wait till the end, just however you want to do it. I just want it to be informal, because like I say, I learned from you more than you learned from me. So another thing I just happened to glance down, we talked about the trust holding title to all your assets, and that avoids the probate process. The next number 6 under that, what is number 3.6? Oh, the fixed share and charitable gifts. If you do your will in accordance with Sharia, if you just say I'm going to do it in accordance with Sharia, it's going to include the charitable gifts. So I'm not going to get into that too much, but we do have provisions in the wills that we draft, typically providing that those obligations under Sharia are going to be taken care of, along with our other debts that are going to be paid before the distributions are made to our heirs. Number 4, when an irrevocable trust becomes or may be needed. Shall we get into that a little bit?
We should.
Okay.
If you can also explain probate.
Probate.
Yeah, a lot of people will not know what is the probate.
Okay. What is the probate? When you have a will, and when you pass away, you have the will, and you go, here it is. I need to have in the will. You appoint a personal representative, and then typically it's your spouse. That'll be the personal representative, your surviving spouse. Can be a brother, can be a friend, can be a trusted, anybody that you trust to take care of your estate once you're dead. Who you appoint is the personal representative of your estate, and sometimes they refer to them as the administrator of the estate. They're basically charged, as you appointed them to be the personal representative, they are charged with being sure that your estate is distributed in accordance with your will. And it's basically a fiduciary responsibility that they are required to comply with your directions. If there's vagueness in the corrections, they may have to get clarification from the court. And that leads to another tangent that I like to see added. Some trust, but it's up to the individual. For example, when I said if there's a difference that it has to be referred to the court to make the decision, you can put in your will that if there's any question regarding the interpretation of this will, I desire that imam or trusted Islamic individuals, it could be one or two or three or a committee, I desire that these individuals make that determination so that it doesn't have to go be determined by a judge. So that's another tangent that I think is a good idea. I don't think I put that in my report here. So anyway, what the personal representative then has to do is take your will, which you've signed either holographic or you've signed before two witnesses and a notary. And the courts say, well, a lot of times people falsify documents, so, and which is true. So you've got to bring that will, you got to file it with the court, with the county court, and where you live, maybe Cleveland County or Oklahoma County. You file it with the court, okay? You file for a probate. I want to file to probate this estate. And you file the notice of the probate, and that'll have about a 20-day notice period, 30-day notice period that you got to publish it in the paper. So anybody that says, well, I knew him and he said he's going to leave me his piece of art or something, and I need to file a claim with the probate so I can get it. But anybody wants to challenge it or say that there's debts owed, they can see that notice of the probate and they file a claim with the personal representative. And the personal representative collects all those claims, and if he or she determines that they are bona fide, they'll approve them for payment, and they'll pay that out of the estate before any of the to the heirs are made. And so you got the public notice thing. Now, public notice, there may not be anybody that files a claim, which is often the case. And then, but anyway, you still have to have that notice period. And then you got the judge then has to say, well, okay, nobody contested this, so we're going to determine that the will is valid. Because somebody could also come in and contest, they didn't really sign that will, or the witnesses are improper, and contest it for all kinds of reasons. The judge has to decide, well, it's a legitimate will, the signatures are official. And so then the personal representative has to file a report with the court. This is another notice period, that here's all the assets we've been accumulating, that we've been able to discover, and here's all the debts that we've been able to discover, and here's our accounting. And they file that accounting with the court, unless all the beneficiaries waive it. And then that accounting becomes public record. But it takes time, so you can see where this is taking time. After all those bills have been paid, then the personal representative goes to the judge and says, we got all the bills paid and we've got this much left and we're going to distribute it to these individuals. And the judge says, okay, distribute it. So then he distributes it, and then he's got to go back to the court and say, we distributed all this property. And the judge says, well, I can see your evidence that you distributed all the property in accordance with the will as I've interpreted it. So this probate is closed. And you can see through all those notice periods and all those hearings, your personal representative is having to spend a lot of time in court. And if you've ever been to court, it's really not a fun experience. I mean, so that's the probate process. But, oh, I'm sorry.
Can you ask me a question, or are you just gonna?
Sure.
What is the best way to avoid probate?
Place your assets in a revocable trust. Either that or give them all away while you're alive.
But if you don't have any real estate property and all you got is cash in one house, do you still have to have a trust?
Mr. Riggs, do you mind repeating the question?
No, not really. I think, you've got to prepare a will to be in compliance with Sharia is my understanding. But there are ways to have there are ways to title property. You can have it as joint tenants with right of survivorship, where if the two of you own the real estate, then one of you dies, the other automatically gets the property. Problem with that is, what if both of you die? So then you still have to go through that intestate process if you don't have a will saying. Now, you wouldn't have to probate it, because your deed that says joint tenancy with right of survivorship is going to take care of the transfer to their surviving spouse, unless both of you pass away, and then it becomes an issue of who gets it now. So that was one way to avoid probate on that real estate, or if there's title to it. And you can also do that with a bank account. You can have a payable upon death clause. And then with life insurance or your insurance policies, you have beneficiaries. And on the same is true with IRAs or your retirement accounts that have beneficiaries. So those assets should be taken care of as long as everything's included, everything's taken care of that way. It's good to have a will just in case. I always do a will even though we have everything in the trust, even though I've got all the assets in the trust, there's not going to be a probate, we're confident. I always do a will, and we refer to it as a pour-over will. And it's a backup will. It says, if there's any assets out there that I forgot to put in my trust or I didn't know I had, then I want them to be distributed in accordance with the terms of my trust. And I've seen that happen. You see it happen in Oklahoma because back in the 30s, the Depression, all the Oklahomans were heading to California because we had the Dust Bowl here in the Depression. Everybody left and they said, I'm going to sell my property. I'm going to sell my land. And back then they didn't know that that land had a lot of oil under it. So they may just sell the surface rights and then get off to California and nobody ever hears from them again. So then here we are 60 years later and they discover oil on that property and they say, who owns the mineral rights? And they look back, well, he just transferred the surface rights, so his estate should still own those mineral rights. So then those mineral rights need to pass through the probate to determine who they belong to. But that's what happens. Sometimes we have, you may inherit something and you may not know about it yet. And so, did that answer your question?
It sure does, but it brings up, I think now, with your input here, I have come to the conclusion that your will override the.
Just a minute,
state
please.
law.
Just a minute.
This comes down to distribution of property.
Excuse me, just a minute, please. So that everybody can listen to your question.
Thank you.
I think that the way I understood you earlier is that that a person's will override the state law for so far as the distribution of property is concerned. Am I right or not?
Yes, as long as you have the proper waiver over that forced division.
Thank you.
They'll still, I don't think it's going to happen in Islam, but in Western society, a spouse could come in and say, or anybody could do it, but I think it's less likely that spouses are going to contest each other's intentions by contesting it in court. Am I wrong?
No,
Maybe.
I think so far as spouse is concerned, you're right, but it comes down to the children.
Mm-hmm.
And if you have raised your kids over in this country,
Mm-hmm.
you don't know whether they actually even believe in Islam or not.
Mm-hmm.
So they may contest that, Sharia type of will.
Well, they are, the children don't have any kind of a forced share like spouses do. So children are not going to be in a position to challenge it so much. However, that is a good point because you may have a child that's kind of gone off the reservation and is out there up to no good. And so you want to cut back on that child and not give him a full share or her a full share. We also like to put a kind of a protective clause in wills, and I'm trying to think what they call it, but a no contest clause. They got a Latin word for it, but it's a no contest clause. And you put in there, if there's anybody in here that has a claim to this estate and I fail to mention them in my will, I did it intentionally. And if those individuals that I intentionally left out of my will come and contest it for any reason, I double down, leave them out of my will. So basically it's a waiver that it's a statement that anybody that I left out of this, that covers you from accidentally leaving a son out or daughter out, or anybody I left out of this that would otherwise have a claim to it, I intentionally did it. That way they can, oh, it's a mistake. So does that answer your question? You see how each of these topics goes on and on. That's why I think that to the extent that we can continue the learning experience together, then maybe we'll have other opportunities to cover some of these things in more detail.
Yes, yes.
But there's another question?
I have a question about having a will as well as a revocable trust, for the real estate. So what do you suggest? Like, as we have been hearing that for 401k plan as well as IRAs, you don't need a trust. You can just have beneficiaries in the said organization and they will distribute it. But for property, is it necessary to have a trust? Or we can just have a will?
Well, you can just have a will, but the title of the property then would have to be determined to be legitimate in a probate. If you just have a will, the property is going to have to pass through probate unless on that deed to that property you have that joint tenants with right of survivorship clause, in which case the property passes to the survivor of the two partners or the spouses. So there a will is not necessary. Problem is, if both of you die, then what? So it's good to have a will anyways, but it's good to have a will regardless whether or not it's even probated, because if somebody has a contest and it goes to probate, then the will is going to govern. But it's always a good, with real estate, if you don't have that joint tenancy, it's going to have to go through probate so the court can determine how that property is going to be distributed. But there is a way around it, and that you mentioned that. That's good. That's a good point. And I'm sorry, I forgot the second part of your question.
So there's a secondary question that I have is regarding if you have a trust, how do you select the guarantor of the trust? Can they be the survivors?
The guarantors.
Like who are going to distribute your trust?
Pardon me?
People or survivors who are
Okay.
going to be distributing your trust.
It's like your children.
Yeah.
Those are your beneficiaries. And we talked about the distribution, or Mr. Nasser talked about the distribution, about the Sharia required distributions. So what I do is I set forth in the trust agreement, and if you don't have a trust, then these same provisions would be provided in the will. But I do it in the trust agreement because ideally all the assets will be in the trust agreement. Now, once you get those assets into that revocable trust, they're no longer considered part of your estate, so it doesn't have to be probated. So you deed that property into your trust by saying, I, Joe Doe's, deed this property to Joe Doe as trustee of the Joe Doe Trust. And so now you've got it in the revocable trust over here, and so it's not a part of your probate. And in that trust agreement, I have a provision that basically says that after the debts have been paid and charitable gifts and special distributions, like if you want your mother to have the library or whatever, special bequests like that, I put in there what the Sharia says at the time that the will is written regarding who's going to get what. And I'll list the kids out. This child is going to receive this much, da-da-da-da-da. That is not really necessary, although I put it in there for clarity, because I don't want some Oklahoma judge trying to determine what a Sharia distribution is. Sorry, judge. But so I spell it out. But I also have a provision in there because your family members are going to change, okay? Sharia is not going to change. But you may have a son that predeceases you, in which case that son's share would go to the other siblings. So when you wrote the will, or the trust agreement, that son was included in the distribution. But I have a kind of a catch-all phrase that says, the personal representative or the successor trustee of this trust is going to review my family situation at the time of my death and determine that the above distributions remain in compliance with Sharia. So that's how the trust takes care of the distribution of the assets, specifically in compliance with your intention and with Sharia. And that opens a whole bunch of doors too, because you have control over how those assets are going to be distributed. Now, Sharia requires that the gift be outright and free of trust upon your death, outright and free of trust. It doesn't say free of trust, it says the gifts are to be outright gifts.
Is that going to be changed for a funded versus non-funded trust?
Yes, a non-funded trust that will apply to your irrevocable trust. It's not going to apply to your revocable trust. The revocable trust doesn't have any funding requirements. You need to set some cash in a bank account or at least in a drawer and designate that the trust has an asset, whether it's a $10 bill or a book. You have to put an asset into the trust for it to become in effect, because that's the corpus of the trust. That's the blood of the trust. If it doesn't have any blood at all, it's dead, so it's void. So as soon as you set up the trust, you need to put $10 in. And I have a phrase in there, contemporaneously with setting up this trust, we've placed $100 in a bank account or $100 in such location. So that's just one of the prerequisites for getting the trust legally established.
So my last question is that, what do you suggest, to have a funded or non-funded trust?
Well, it depends on the individual, because we were getting ready to talk about the irrevocable trust and the need for an irrevocable trust, or the possible need for it. I personally do not, most people do not need an irrevocable trust. Irrevocable trusts require for specific distributions for specific people or specific beneficiaries, which can even include yourself, and they can provide that this trust is going to provide for your health, education, maintenance, and welfare for the rest of your life. And those may require that you fund some of those deposits to take care of those obligations. And those typically, an irrevocable trust, drink. This is where things change, I think, and from my perspective anyway. A lot of attorneys may see it differently and for good purposes. But if you remember, I think it was in July 4th of this year, they passed the big, beautiful bill that changed the estate tax rates. And prior to that, it was up in the air because the Democrats want to do away with the estate tax deduction. I mean, this is my opinion, maybe, but the estate tax deduction at the time was something like $14 million for each individual. No, back up. How much was it?
26.
That's what it is now, or that's what it is now. But they were going to reduce the estate tax exemption, and they were talking they were going to reduce it to 5 million or so, and that may happen in the future. But most of this estate planning, where you're setting up irrevocable trust, was the idea was to get the assets out of your control, out of your name, and that way they're not included in your estate for estate tax purposes. Your revocable trust is still going to be included in your estate for estate tax purposes. But to the extent you gift that property to the irrevocable trust, then that property leaves your control. And that irrevocable trust will set up its own taxpayer identification number and file its own tax returns and pay its own income tax. But the benefit of that is it protects the assets from being in your estate. But the downfall of it is you lose control of the assets. So, but that's not a problem anymore for estate tax purposes for 99% of the people, because after that big, beautiful bill, for a married couple, it's like $30 million that's going to be exempt from estate taxes. So why go to the problem of putting your assets into an irrevocable trust that's out of your control if it's already exempt and there's not going to be any estate taxes regardless? Now, if you're worth more than 30 million, you need to do some deeper digging, and we set up some trusts and start doing some gifting. Also, if you want to reduce the size of your estate, I think it's $19,000 a year you can give away without there being any gift tax and without it applying to your estate tax deduction. So between you and your wife, he's given, and check the numbers, but if you and your wife want to give between the two of you $32,000 a year to each of your 25 grandchildren, you can do that, and that's not going to be included in your estate tax. You can do that every year. And a lot of people will do that to reduce the size of their estate. And you don't want your grandkids to have all that money right now? Well, instead of just giving it to them directly, set it up in a trust or an account where they can't reach it until they reach a certain age or a certain level of maturity. Or sometimes a parent knows that son or whatever is probably not ever going to be financially responsible. So we want that child, and I think that's in compliance with Sharia, forgive me, but the Sharia calls for maturity. And if the child is not responsible, is not mature, so it may never reach maturity. I don't know. But you're still gifting the property to the child via the irrevocable trust. Although the trust is, the money is held in that irrevocable trust to follow your directions, that this child's going to receive $5,000 a month or $5,000 a year until he turns 50, or for the rest of their life, and then it's going to go to his children or siblings. So that's where that's the primary objective, in my opinion, for the irrevocable trust. There are many other objectives where you want to set up a special trust fund for maybe you have an autistic child or something. So you want to set up a trust that's going to provide for the autistic child, or your mother, you want to provide for the care. So there's all kinds of specific reasons. And then a lot of people will come in and say, I say a lot of people, some people, they'll come in and say, well, you need to get the assets out of your control. So if you get sued by somebody that slips on a banana peel and they get $1 million verdict against you, they can't come after those assets. So people put their assets in an irrevocable trust to try to protect them from creditors.
But who controls that trust?
You will appoint somebody that you honor and trust, and I would suggest somebody that's familiar, knows as much as possible about Islam, so that they can understand your intentions. But that's who you choose who it wants to be. Typically, it's the spouse. I say typically, but it can be your brother or uncle. Maybe the spouse doesn't want to get involved in it, and maybe it's a numbers deal, and the spouse doesn't do numbers. So then any trusted individual. A lot of people will pick a banker to do it. And a lot of times that's beneficial, because if there's a lot of paperwork involved in accounting, bookkeeping, collecting revenue and all this, they've got the clientele, they got the trust department to keep up with it. But it could be your brother, your wife,
But it's after his life.
after
Right.
after you pass away.
Yeah, but before he passes, he still controls.
Not on
it.
an irrevocable trust. On an irrevocable trust, you have to hand over that control when you hand over the property to the irrevocable trust.
Right, but in revocable trust, he will have control.
In a revocable trust, you have complete control over those assets to do with whatever you want, as long as you live, or as long as you instruct the trust to put it into an irrevocable trust for a special purpose. And those kind of, I'm sorry.
I've heard something, you can put your trust in an LLC, you familiar with that?
Put the microphone.
Can you
for
put the
sisters.
mic?
That putting your trust and all your assets and everything else in an LLC.
Yes.
Okay, that's a little bit backwards than the way I typically do it, but typically, and that gets on that point of protecting your assets from creditors. If you have a real estate property or you have a business of any kind, it's a good idea to get that out of your name, because then if creditors slip on a banana peel in front of your dry cleaners or whatever, then they want to sue you personally. So you want to, and that's not likely to happen, in my opinion. Those lawsuits are rare, and I think a lot of attorneys, and California attorneys, no Oklahoma attorney would do this, but you got to have an irrevocable trust to protect your assets because somebody might bump into your car and sue you for $1 million. That is very remote, and I don't think it's worth the risk of going to the trouble to set up an irrevocable trust, putting the assets out of your control just to protect against a possible creditor. Now, somebody might say, well, I know I'm going to get sued, so I'm going to get my assets out of my name, and I'm going to put them in an irrevocable trust. But the problem with that, it's a little late, because they have look back rules. The courts will look back, and if you set up that irrevocable trust within, it can be 1 year or 2 years, even sometimes 5 years. If you set that if within 2 years prior to you setting up that trust, you knew or should have known that there was this claim that was about to hit you, and they say that's the reason you set up that trust, to avoid that claim, then they will null your trust with regard to that claim. So people that want to put it in there to protect against a possible lawsuit, that's probably not going to work, especially if you knew that lawsuit was coming down the road. But that's one reason a lot of people set up irrevocable trusts.
So another question, I'm sorry, just things coming to my mind.
Thank you.
For an irrevocable trust, can protect us from long-term care, or, if we are, kind of disabled, living in a nursing home, or nobody to take care of ourselves, and can an irrevocable trust protect us from the creditor?
Mm-hmm. Yeah, when you're talking about the nursing home, I don't know, is it Medicaid or Medicare? But we were talking about setting up the revocable trust, because Medicare, which one is it that does the nursing homes? Medicaid. Medicaid can come back 5 years. So if you say grandma's I'm about to go into the nursing home and I don't want to have to pay for it, I want the state to pay for it. So that has a couple of problems, but the state, the Medicaid people in all their wisdom say, oh, they just set up that trust so they didn't have to pay for the nursing home. So what they'll come in and do, and they'll look at your assets and whether you set anything up like an irrevocable trust within the last 5 years, and then they can go after it. So, typically, I don't think it's a good idea to set up an irrevocable trust to cover nursing homes. And my primary concern, and I may be wrong about this too, but I used to have some involvement in nursing homes. I'm not going to get into that, but if you've been to a nursing home in Oklahoma, it's not someplace that you necessarily want to be or put a loved one. They have private care nursing homes that are really nice, but the private care, I don't think Medicaid is going to contribute too much to anyways. But I think a preferable solution, and there's going to be different opinions, but rather than setting up that irrevocable trust to provide for your spouse's nursing home, which you see coming down the road, I think it's preferable, and the expense would determine, but to buy a nursing home insurance policy. And that gets back to the liability. If you're afraid you're going to slip on a banana peel and get sued for $1 million, your homeowner's umbrella insurance policy will typically cover that. And those umbrella policies are cheap. you can, I don't know, get $1 million for just of coverage for a few bucks. So rather than going to put it in a irrevocable trust because you think somebody's going to slip on a banana peel and sue you for everything you got, one, that's probably not going to happen. And two, if it does happen, you got your umbrella policy going to take care of it. So back to your question, I forgot, we were jumping back and forth, but you asked about the LLC and the trust. And so I wanted, and I mentioned that I do it kind of backwards than what you were talking about, but it may work both ways. But typically, if you have a piece of real estate or business, you want to put it in an LLC just to, if you're more likely to get sued at a business where people are coming and going all the time. So it's good to get that out of your name. And if you put it in a LLC, that puts it out of your name, okay? And then you can also use that LLC to start distributing your assets to your children, like give them 10% a year, or start getting them involved in the business. And you can set up a management plan on that LLC, who's going to manage the property after you're gone. You can go into all kinds of detail on that. But typically the LLC is owned by members, okay? You got members kind of like the stockholders. And the boss of the LLC, the manager, the director, is typically you or somebody that you've appointed. And so that is referred to as a managing member. These other members do not get to manage. So you can set up that LLC, have your kids in as just members, but you're the managing member, so you make all the decisions until you die or until you don't want to mess with it anymore, and then you can appoint somebody else. But those membership interests, and you may own the whole LLC, but whatever percentage of that LLC and you own as a member interest, you assign that member interest to your trust. And then that member interest is in your trust, and it's going to be distributed in accordance with the distribution that you've set forth in your trust for all of your assets. Unless you specify that I want my daughter to receive this specific interest as part of her Islamic distribution, the LLC interest. So that's a way to divide your estate. But where it's backwards is the LLC interest, then, because you got the creditor protection from the LLC. And then you kind of got double protection because then it's in the trust. So it completely bypasses you. And then there's also, I know I'm getting off into the woods here, but with an LLC, if that LLC gets sued, they have what they refer to in Oklahoma as a charging order. So that LLC gets sued and they want to go after partner A's interest in it because they got a judgment against partner A. There's a charging order where they can be prevented from attaching the LLC assets because of that one partner. So that's another advantage of the LLC.
So let's go over some of the questions women have.
Oh, great. Thank
We
you.
will come back to inshallah. Just a few minutes.
Okay, so we have some questions from the sister side. One sister asked a question. It's a little long, related to living trust. So she asked, what is a living trust? What are the pros and cons of a living trust? And can you make a living trust on your own without an attorney? Can you pull all your assets into a living trust? House, bank accounts, etc. You want me to read that again?
No, I mean, I think the living trust that you're referring to is the same thing as the revocable trust. Sometimes they're referred to as a revocable living trust. I think the term living trust can sometimes be referred to as healthcare directives and durable powers of attorney and things like that. But yes, you can prepare it, and yes, you can do it without an attorney. And I don't think it's going to be as simple as the holographic. I think, okay, and then maybe this will be on the recording, but here's what I would do just off the cuff if I was wanting to do it without having to get an attorney involved, which is understandable. But let me go over the components of a trust, of a revocable trust, where you can do it yourself. But I have no guarantees. That is good. Courts like to see it all written out. But if you want, you can have a trust orally in Oklahoma. You can say, I'm putting this money over here to hold in. I'm going to give you this money to hold in trust for my kid when she gets big. That's enforceable, but good luck getting them to hold true to that promise if you don't have it in writing. So you put your assets. So that gets to that. I'm going to go back to my components. So if you're going to do your own trust, which I don't necessarily recommend, but a lot of people are smarter than I am, so they may do a better job than I do. But you got three parties to a trust. Okay, you got the trustor, who's the executor, the creator of the trust, and that's typically you or you and your spouse. And you set up a trust, you're the trustor, you set up the trust, and you put all your assets into the trust, okay? You are the creator of the trust, and the trust is for your benefit. You are the master of this. But then you appoint who's going to be, you own the trust as the trustor, who's going to manage the trust, who's going to make the decisions. Well, since you set up the trust, the revocable trust, since you set it up and you still control the assets, typically you want to be the trustee of the trust, the manager of the trust, the boss, the director, the president. So you got the guy that sets it, you got the husband and wife typically, or individual that sets up the trust, and then that's the trustor or executor. I think they call it, they probably got other names for it. But then you got the trustee, who is the manager, and that's typically you, the same person, okay? Then you got a third party to the trust, and that's the beneficiary. Who's going to get the benefit of that trust? Who's that going to be for the benefit of? And what we typically do is we provide that the beneficiary is also you and your spouse and your family. And that's, the trust is established to provide for the health, welfare, and support of my family, me and my family. And we can do whatever we want to, as long as whatever we want to with this money, but that's the specific purpose, to provide for us. And then, so you've got it all in your control. And then to the extent you want to put it into a special purpose trust, then you talk about putting it aside for a special purpose trust. Did I get off track? Did I answer your question? What was the question? Don't repeat it. But how to set up a trust on your own, how to do it yourself.
So those were the components.
Pardon me?
Those were the components, 3 components.
3 components?
Yes, of the trust.
Did I get one of them?
Yeah, no, those were the 3.
Okay, well, those are the 3 parties to a trust. Okay, so you're going to want to include those 3 parties when you're writing your own trust. You're going to want to include who is the trustor, you, who is the trustee, you, who is the beneficiary, you. And then you're going to go down into the trust and you say, however, what's going to happen when I die and I'm not the trustee anymore? You're still the trustor, because you will always be the trustor, because you're the one that created it. But after you're dead, you can't be the trustee anymore because you're dead. So you got to say, I'm going to appoint my brother or my sister or my son or my daughter or my friend, a competent adult that you trust to handle your estate. And then you're going to appoint, that's going to be the successor trustee. Okay? Successor trustee. And you can have, if you want, 2 or 3 or 4 or 5 successor trustees. You can have a trustee here and a trustee to cover your property in Pakistan or whatever. Trustee over your corporate interest, a trustee over your farm interest. Trustee for one, but typically it's one trustee. But then you got to have a little bit of a backup when you're doing your own trust. Say, I'm going to appoint my sister to be the trustee after, if I die, and my trustee is going to follow my directions that I have set out in this trust document, which is going to provide who's going to care for your children. Do you want them to be able to attend the university? Do you want them to receive all the distribution at once as soon as they reach the age of 18? Or do you want them to receive it over time, because maturity takes time? So those kind of provisions you want to put in there, and you want to get as specific as you can, but at the same time being clear. And to the extent you can reference Sharia, and that kind of gives a backup to where to double check your figures if you want to. Now, when it comes to Sharia, what I typically include, and this is, I'm getting off track again. Don't get me off track too far, but I go to the web and I get on, it's called IRTH, IRTH, or Islamic Inheritance Software. And it has a real easy little form. You put in your wife's name, husband's name, mother's name, father's name, siblings' name, and you got all that. You don't put their name in there. You just put how many of each you have: 1 wife, 1 husband, 3 children, and hit press, and it calculates it all. And so, but
What is it called again?
IRTH, IRTH, Islamic Inheritance Software, and it saves me from having to calculate it, since I'll probably get it wrong anyways.
I've got a question about the trustee.
About the what?
About the trustee. You said that the trustor is the one who starts the trust, initiates it. For example, if you and your spouse are both the trustors, because you started the trust, and then if one of you is a trustee, in case of your death, will you not, you mentioned that you can appoint someone else as trustee, and you can mention that if I die, your brother or your sister or somebody can, will your surviving spouse will not automatically become the trustee, the manager of the trust?
It's up to you. Sometimes, and I say typically it's the husband and wife that are the trustees, the initial trustees. Sometimes the wife or the husband doesn't want to have to be involved in it. And they said, don't make me a trustee. And so just one spouse will be the trustee. And then when they die, they pick a successor. Typically when it's a husband and wife, like you say, it says, okay, one spouse dies, the surviving spouse will be the trustee, and the surviving spouse dies. Then we appoint this and this and this. And it's a good idea to appoint 2 or 3 successor trustees, because what if you and your spouse die and you appointed your brother and your brother predeceases you or doesn't want to do it or is not able to do it? So it's good to have a backup and a backup. I've had people, several
What
backups.
if we want that if the husband and wife both pass away, then the trust, everything goes to the beneficiaries?
It depends that depends upon the trust agreement. You can provide that the distributions are to be made immediately, or you can provide that certain distributions for certain of your heirs are to be held in trust until, like, I'm going to hold this in trust for my children until they reach the age of 18. Or I'm going to hold it, we're going to continue to hold it in trust for these children to be distributed to them, so much to go to college, so much for a residence, so much if they get married, and then so much of an allowance for 10, 15, 20 years.
I understand. My second question was that, for example, if most of your assets are in real estate,
Mhm.
and you and your spouse, you are a trustor,
Mhm.
and one of you is a trustee, and you have your kids who are the beneficiaries, to transfer your real estate into the revocable trust, will it be advisable that you first transfer all your assets in an LLC and then start a trust? You can directly put your real estate in the trust.
I think it's a good idea to put it into an LLC and then put the member interest in the LLC into the trust, because the LLC, I think, is the best source of protection against creditors. Like if you have real estate and you got a farm and somebody's trespassing and they break their leg and they want to sue you. But and also it provides a means whereby you may start sharing interest in that LLC with your children as time goes by, if you desire. And you can also in that LLC, in the LLC agreement, you're going to provide who's going to be the employees and who's going to manage, and you can provide directions for your heirs via the LLC on how they're to manage and maintain the business afterwards. But that's a good question, and I'm sure there's different ideas on that too. And but the thing, another beautiful thing about an LLC, and what we talked about, the members over here, and then they got the manager over here. Say you got so much in your estate, you want to start getting stuff out of your estate, start the distribution, start setting your kids up or whatever. But your kids don't want to run the business, or they want to have limited operations in the business. So you keep 1% of the LLC as a member interest, but you remain the manager, the boss, and you call the shots. And your children are just members, so they don't get to call the shots, even though they own 99%. Okay, so I think that's another advantage, and it's a good idea to have an LLC if you have those kind of interests.
So ideally, you should distribute your wealth within your lifetime.
I think so, to the extent that you can. I think then you see it happen. You see it's going in accordance with your directions, provided you and your wife and you've got everything set aside to take care of yourself, and you get to see your kids taking over the property, and you get to help them along as they're developing their interests and their knowledge. So I think it's a good idea if you can. It's not really going to save you estate taxes now, since there's that huge $30 million exemption. And as I mentioned, I don't think it's really not going to offer that great of protection from creditors, because your insurance coverage is going to cover it most of the time. But I think it's a good idea to get your kids involved in the business while you're alive, so that they can learn from you, see how it's done.
So the question was, is it a good idea to distribute the property while you are alive? So that was the question.
I think just for the same reason, I think it's a good idea just to get your kids planted in their roles, and they're not then going, I wish Dad was here to tell me what to do, because they had you teach them. That's the only reason that I think it's good to go ahead and give it away from the kids with this $30 million exemption. If the exemptions were going to be 5 million or 1 million, what they were talking about doing, then you want to get it out of your estate, because if it's beyond that 1 million or 5 million, then it could be taxed at 40%. The government take 40% of your estate. So, but that's not, with it 30 million now, that's not going to apply to most people. Yes? I'm
One
sorry.
more question. One more question is that obviously, you know, if we want to transfer some parts of the, or some assets to the kids while we are alive, then we don't have to put them obviously in the trust. But for example, you have started an LLC
Mhm.
and then you put that LLC and all those assets in the trust.
Mhm.
Now, you know, as I understand, we can do it in two ways. For example, if, for example, we want to give as according to Sharia law, if you've got one son and two daughters, the 50% would go to the son and 25% would go to the daughters.
Mhm.
Would you suggest that we make them members having that share in the LLC, or we don't have to mention that the LLC and we can only put it in the trust?
So
After your,
both. I think it, you know, the clearer you can make it, the better it is, and that way you can look at either document and tell what's going on. But back to the whether you should give it now or the one share for the son and half share for the daughters. Correct me if I'm wrong, but I would contemplate that since you're making that gift while you are alive, those gifts you make while you're alive don't necessarily have to comply with those distributions that Sharia sets forth upon your death. I mean, in other words, you can give whatever you want to whoever you want while you're alive. So I think it's up to you if you want to allocate it in accordance with those distributions they would receive had they waited till you were dead to receive it.
since it is
There is some kind of IRS ruling that you can distribute up to $18,000 per grandkid or per child every year.
Mhm.
Are you familiar with that? or-
Yes, we talked about that a little bit ago, where you could give up to I don't know if I said 18,000, I said 17,000, but you and your wife can give up to twice that amount to each grandchild every year to reduce the size of your estate. If you have 30 grandchildren, you can leave each of them, let's say $32,000 every year. And that can drain your estate pretty quickly if you're wanting to take care of all those kids. Now that would, I think, also qualify as a gift, which doesn't necessarily come out of those Islamic distributions. Does that answer your question?
That would answer the question. And I think somebody who's in latter year of their life, like 80 plus, that might be the thing to do.
It makes it easier.
Yeah.
I mean, after you're passed away, if you've taken care of that, think if you're a child and your dad passes away, and then you got to go through the probate and you got to handle all the paperwork and all. The more of that stuff you can take care of while you're alive, the easier it's going to be on your survivors. But you don't want to jeopardize your own health and welfare because you've given everything away. Now that's where you can, I mean, on an irrevocable trust, you can set it up so that so much is set aside for your care, okay? You don't have to give it all away, but you want to be sure that you're taken care of.
So you mentioned distributing the wealth while you're alive to your kids. Can you do so also with the trust? So, and it won't be also like accountable on you that you didn't do it due to the Sharia law? Or
if the trust, yeah, if the trust distributes the property, typically it provides that distribute on a revocable trust. It typically provides that distribution is going to occur upon your death. But you can also, according to the documents we set up, you can gift whatever you want during your lifetime.
so it's not, so I have to do it without the trust then, so it doesn't like on me as like I'm doing something that's not Islamic, I guess.
No, because no, it's clearly. I mean, I think anytime there's a question like that has to do with interpretation of Islam, I think that it's very important that it be as clear as possible. And it's not like we're trying to get around anything or subvert, but we're going to make it transparent. And we're going to put it all on the table. And that's why in the trust, it says you can gift whatever you want. And that's my understanding in Sharia is that while you're alive, you can give away whatever you want. And you don't have to comply with those distributions that you would have had to do if it waited till you died. Because the purpose of the will in the purpose of those distributions is to provide for your heirs after your death. And the purpose of the trust is, the revocable trust is to take care of you and your family while you're alive. And that includes you giving whoever you want, whatever you want while you're alive. So you still have full control when you're alive, but when you die, then it becomes out of your control and distributed in accordance with Sharia or your intentions. So I don't think it's playing a game, and I don't think it's unfair. I think it's contemplated in the Sharia.
So
Right.
it's just to be clear, this inheritance rules are applicable after you die. In your lifetime, you can equally distribute.
So after I die, even though if it's in the trust, and the trust does not follow the Sharia, what happens? Like,
If the trust doesn't comply with Sharia, if there's a dispute over the application of the trust, that's one of the things that I would have, that I mentioned earlier, that it's a good idea to put in the trust, if you're doing it yourself, back to that subject. It's a good idea to put in the trust who you desire to be the personal representative or the trustee, successor trustee after you're gone. But while you're alive, you can give it to whoever you want. But if your trust says, I'm going to leave it half and half to my children, regardless of their gender, that I don't think, obviously does not comply with Sharia the way it's written. So, but it would be enforceable in state court, but it would not be in compliance with Sharia.
because when you put the stuff in the trust, then it may not belong to you anymore, right? Like, if
No, it's still, everything in the revocable trust still belongs to you.
the irrevocable one, it does not belong to you.
Right.
So you can distribute it similar way if you are alive, distributing it, whether to the Sharia law or not. And that does not.
Yes. Because in effect, when you give the property to the irrevocable trust, you're giving the interest in that property, although it may be a future interest, to the beneficiary. So that is a gift while you are alive. So I would interpret that, and I'm open to interpretations I would interpret that to be a gift and not subject to distribution under your will or estate laws, or even those distributions required by Sharia. Because to my knowledge, those only apply to distributions upon death. Now that's that's a really good question, and I'm really open to it, because I could see somebody arguing, well, you didn't really give them a full gift because they didn't have complete control over it. But arguably, it is a full gift because you gave them that future interest in it. I kept the present interest, and those are legally separate. You can record that in the county that I have a present interest from this period to this period, and so has future interest. And any of those you can get an appraisal on and have a value on, and you can place that value in your calculation of the percentages. Now, I suppose on that you could specify in your gifts that I'm going to give this to you while you're alive, but I want this to count toward your Islamic distribution, and have that math come into play when the death distributions are made, that you already received those as an advancement of your death, of the distribution you're going to receive upon death. So I think you could structure it either way, but you want to, and so that another question that that I always had that I welcome input on is that maturity, when the kids are going to receive their distributions.
One more, please. So if you have a will only, that's going to go through probate. You have to go through court, no matter what. If you have only a will, you have to have a trust so you can avoid the courts.
That's right. Except if I guarantee you there's thousands of people that have wills that never get them probated because they have their property in their joint tenancy with right of survivorship, or everything's through beneficiaries, the payable upon death clause, and all the bank accounts and everything covered except for the personal stuff like the piano and the artwork or whatever. And the family says, oh, you take that and I'll take that, and you take that and I'll take that, and everybody takes what they can, and they go on about their business, and there was never a probate. Okay, so I think that happens a lot. It's not, I say it has to go through probate, and the statutes say it has to go through probate, but in reality, a lot of people do it on their own. Okay.
And the cost of the will, not much compared to the trust. The trust, like, $5,000 or less, or is that how much usually the cost for the trust?
It depends. Are you talking about legal fees for preparing one?
Yeah.
I don't know, whatever you got. I'm joking, I'm sorry. No, typically,
Usually what I'm saying is like people, that's why they don't want to go through a trust, maybe because financial reasons, they do it with a will, but then they have to go through the hassle of courts, I guess.
yeah, and that's what the lady was asking earlier, as how do you do it yourself? And that's why I explained that you could do it yourself. And even, like I say, Oklahoma law, trust does not even have to be in writing, but you definitely want it in writing. But you could do it you can do it yourself, as provided you have the trustee, the trustor, and the beneficiaries. You got those parties named, you got the successor trustee named, you got your directions on what you want to happen to that trust property. Why are you holding it in trust? You say, I'm holding it in trust for this purpose, to provide for this and to distribute these assets when I die, in accordance with Sharia, in accordance with what I've set forth below. And that is a legal trust document, and that keeps your assets from having to go through probate. I don't suggest doing it on your own, because you never know what some judge is going to, I think judges sometimes, I've seen this happen, like you file something and they don't like the way it looks, so they throw it out. I mean, that's not right, but you got personalities involved, and these are elected officials. So that's another reason to keep it out of the probate. But the do-it-yourself trust, if you have those components, it's going to work, okay?
So the question is, if a trust was established in Oklahoma or under Oklahoma laws, and the person moves to another state, will it be valid?
I would have to look at the state and see if there's any kind of differences, but typically it's going to be, wills from one state are going to be respected in another state. Now, to the extent you get real estate if you get real estate in another state, I would want to be sure all those payable by death clauses or the statutes are the same. But typically any state you move to is going to honor upon the trust.
So what I understand with all this explanation is that the real estate that you own, for example, it's you have the title is in your and your spouse's name. And when you establish the trust, the revocable trust, everything remains the same. You have got full control of that property. You can add properties, sell out of that, transfer that property to whoever you want.
Just like you do now.
That's what you know.
The only difference is you're signing it as trustee of the trust instead of as an individual.
And then we are, as the properties are with us now, it's the same thing if they are in the trust. And then in the trust, we can say in case both the spouse die, then it will be immediately distributed this proportion to the children. Is that right? Okay. And
Basically, the trust takes the place of the will as the testamentary document. The trust takes the place of testamentary, I mean, describing your intentions regarding your estate. The trust sets forth in detail everything that you need to do. And that's a beautiful thing about being able to put it in the trust, because if you put it in your will, that will gets filed a public record, and anybody can go look at that will and say, well, look what he did with all his money. But if a trust, the trust is a private agreement, and you may go to a bank, or you may go to somebody may need a copy of a trust. We prepare a one-page certificate of trust, which is permitted by statute, which shows the authority of the trust. So that trust document itself remains private.
if the real estate is in the name of both spouses, for example, that is what you call joint tenants with rights of survivorship.
Not unless it specifically states that it's joint tenancy with right of survivorship. And sometimes they'll just use the initials like JTOV or something like JTROV.
And it does not matter how many people can be joint tenants. For example, is it possible that, for example, if the real estate is in your and your spouse's name, you can add your two children as in its title as tenants with joint survivorship?
You could do that. I would be a little bit. I would want a little bit more control over how much was distributed to my children and when, because and there may be shortcuts around it, but to the extent you and your wife die and there's two children here, and they both own the property, are there going to be any restrictions? Are you just going to, when one of those dies, is the other one going to get the property, or is it going to pass to their children? Specific instructions like that. But if you If you just put it up with joint, if you got 4 A, B, C, D, E, have joint tenants with right of survivorship, as I understand it. First one dies, the remaining 3 are going to split the share. Second one dies, the remaining 2 are going to split the share. Third one dies, the last one's going to get it all. So you want to specify who's going to receive it.
Last question. If you and your wife are a trustor and you have wanted your wife, for example, in case of your death to become the trustee, that she can make any changes during her lifetime in that trust.
Mm-hmm. Unless we put a provision in there that at the death of the first trustee to die, the trust becomes irrevocable. And then at that point, the trust is going to be distributed in accordance with the terms of the trust. And that's where you get a third party to come in, but that still provides for the wife or this husband to be taken care of for the rest of their life, and usually provides that they're going to be able to live in the residence for the rest of their lives. But by making it irrevocable, it keeps the surviving spouse from being able to change the terms of the trust. And that's a good idea for another reason, is that it's not that you don't trust your spouse, but we all lose it sometimes. What if she gets incompetent? Now, then you got to. So, what if she? You're watching this, but what if somebody else's wife said, "I'm going to go marry this somebody else," and that somebody else has a great idea to make $1 million overnight, and give me all that money, we want to put it in this, and the spouses you got to worry about if they get another spouse. So that's why it's sometimes a good idea to make the trust irrevocable upon the death of the first spouse. So you can appoint an independent trustee to take care of the assets and make sure that the surviving spouse doesn't go off the reservation.
I understand, but that can be done at any time.
Mm-hmm. Yeah, it can be done at any time as long as you're alive and competent to do it.
Anyone else have the question?
Yeah,
Just
I
a
have
minute.
one question, please.
Just a minute. Anyone else have the question? Because we are rotating with 2-3 people. So we do not want to left. Yes, please, let's go and give him the chance, please.
That's one last question regarding distributing your wealth during a lifetime or assets. Suppose you have a 1031 exchange, and you want to gift it to your kid. Is that possible?
Mm-hmm. Well, to the extent you've already distributed it to the kids, it's still going to be possible, but they're going to have to agree to the transaction. I mean, they'll be the ones signing off on the exchange rather than you if they own the property. And so to that extent, it's kind of out of your control. You got to trust them to go along with it. Now, there may be some timing requirements.
Like if they sell it right away, then they might have to pay taxes, right?
If the what?
If they sell the house, for example, in case of a 1031 exchange house, and if you want to gift it to your son or a daughter, and they sell it right away, then they might have to pay taxes on that.
Well, to the extent, okay.
To the extent of the basis of the house.
It depends. Yeah, it depends it depends on the basis in the house, and it depends on whatever, when you do the 1031 exchange, you get to carry your basis over from the property, and that's going to be their basis. Okay. Now here's, excuse me. Here's a big distinction. I don't want to get into it, but it's going to take too long, but I'll try to make it short. But this has to do with the estate taxes too. But if you sell property, if you sell real estate, say you had it over a period of time and it doubled in value, and you just sell it, you're going to pay long-term capital gains on that gain. Okay. You paid $100 for it and you sold it for $200. You're going to pay tax on $100 of the long-term capital gain. Now, if you bought it for $100, maybe worth $200, but if you gift that to your child, they're going to get a carryover basis of that $100. Okay, that's going to be their basis. They turn around and sell for $200. They're going to have to pay tax on $200, just like you would have had to have. But however, this is something I think a lot of people overlook. At least I overlooked it. So if you die and you leave the property to your children upon your death, then they get what they call a stepped up basis. Okay. And so if you die when the property is worth $200, but you paid $100 for it, then they inherit it they get a stepped up basis of 200. So then if they turn around and sell it for 200, they have no gain.
Yeah.
So that's the difference. You got to consider that if you're going to gift a property, where you get a carryover basis, or you're going to give it to you upon your death, which would have a stepped up basis. So it takes some planning. But
Thank you.
opposite would be true if the land went down in value, I suppose. That doesn't happen very often.
Does our legal system recognizes the Sharia distribution or this Sharia law?
You asking me?
Yeah.
I don't know. You'd see the news, and they got stuff going on in Texas. Oh, we're not going to have this Sharia stuff around here. But there was a case in Oklahoma. It's federal lawsuit, but it's a national question, so it's applicable nationwide. But Vicki Miles LaGrange, who was a federal judge here in Oklahoma, federal court, they had the decision on whether or not Sharia was enforceable or not, and she said yes, it is. Now, you got politicians all over the place that got some kind of idea that says, well, we're not going to have it in compliance with Sharia. We're not. So then if you mention the word Sharia in that document, some judge that's on that page length is going to say, oh, that's Sharia, I'm not even going to look at it. But legally, you can do it. You're not going to be blocking some of these judges' bias, which is why the trust comes in. But you can have your trust and will done in compliance with Sharia and in compliance with Oklahoma law at the same time. I put a provision typically in the trust because just to try to get the attention of some of those rogue judges, which I think that try to ignore it. Because in America we supposedly have freedom of religion. So I put in accordance with my right as the freedom of religion, I decided that this be construed and determined in accordance with Sharia. That's legal. Now they might come out. So I'm not saying that who's ever president next year or whatever, but federal courts have said it is enforceable. So I'm going with that. And if somebody says it's not enforceable, I'll take it to the Supreme Court and say, yes, it is. And the Supreme Court might say, oh, we don't like Sharia. We're not going to. You never know what the politicians are going to do. So, but it is compliant.
Now, another question is, if you set up the trust and you die and your kids inherit the property, do they have to pay the taxes?
Mm-hmm. To the extent that the property is a real estate or something is earning income, they pay the tax on the income, yes.
On income, not the real estate value of the property.
Yeah, they'll pay the real estate taxes. They'll own the property, so they'll have to pay the real estate taxes.
But they don't pay the wealth tax, like it.
Yes.
They don't pay tax on that.
No, not on inheritance. In fact, nobody pays a tax on inheritance if their estate's not worth over $30 million between the husband and wife.
I see. So the whatever, county taxes, that they have to pay, or rental income?
No, the ad valorem tax, which is like if you go buy a house, the county charge you ad valorem tax, say you on this cost of the sale of the property, but when you inherit it, you don't have to pay that.
Okay,
Or if you pass it to your children, you don't have to pay that
okay,
because it's not a sale.
okay.
That's a good point.
Any other question?
Yes?
If I have no children, then how is it gonna distribute it if both die, for example, an accident? So what's gonna happen to the property and the 401k and whatever it is?
Well, it'll depend upon what you set forth in your will. And if you don't have children, if you specify who you want to receive it. If it's passed in accordance with Sharia, then the Sharia on that earth calculation, but they have provided for, if you don't have any children, parents, first to receive it can be your siblings and parents and children. And then if you don't have any children, parents, or siblings, then it's going to be distributed to nearest relatives, cousins or uncles and those kind of siblings. But that's all laid out specifically and calculated by Sharia. If you don't have any siblings, then I'm not sure how Sharia distributes it. I would say that it's probably good idea to provide for how you want that distributed. And if you want to put it to the mosque or an Islamic charity, set that out so that if the government gets it, if you die, if somebody died and they didn't have any heirs, I don't care if they're worth $1 million or what, $10. The government, the Secretary of State has this unclaimed property fund. And so that would be considered unclaimed property. The court said, we don't know what to do with this property. So they're going to turn it over. And this is my opinion. There may be some other way around it, but they're going to take that property. There was no will. They don't know who your heirs are, who your beneficiaries are, and they're not going to go digging for it. And they're going to say, we don't know what to do with it. We turn it over to the state. Now there's a little extra motive on turning it over to the state, because if the state has it for 3 years, I think it's 3 years, and they still haven't had the owner, the state gets to keep it. And so you need to have a will and say whether you want it to go to charity, or you may want it to go to the neighbor down the street, or if you have a special cause. It's up to you, but provide that it goes to somewhere, to someone that's going to make you feel good.
Good. Any other question? Okay. Hold on. Yes.
Regarding getting sued,
Mhm.
anybody can get sued,
Mhm.
right?
Mhm.
Can the trust be sued?
Can the trust be sued?
Yes.
No, not a revocable trust. They would sue you as trustee, but they couldn't go after the assets in the trust. I mean, they could go after the assets in the trust, but they would sue you as trustee. Yeah, the revocable trust does not provide protection against getting against a lawsuit. If you got issues with, because the assets in the trust are under your control. And if they're under your control, creditors can attach it. That's why in an irrevocable trust, if you're wanting to protect and not have creditors or frivolous lawsuits come after it, you put it in an irrevocable trust. That's why you have to turn over control. Even though, so people say, oh, I'm going to put it in an irrevocable trust, but I'm going to appoint my brother as trustee and he's going to do whatever I say. Then it's possible that could be overturned because he's not an independent, supposedly objective trustee. So yeah, the trust is a revocable trust is subject to all your creditors' claims, just like it's in your own name. The revocable trust is specifically for the purpose of avoiding probate and providing for your intentions. So, but an irrevocable trust provides for the protection of creditors. But again, you got to look back, and you can't. If you're fixing to get sued, you don't want to do it, because if anything within 2 years, they're going to be able to come back and say you did it. They call it constructive fraud. It's really not fraud. You're just trying to protect your assets, but they call it constructive fraud. It's not criminal, but they can undo it. You say, oh, you put that in the trust, in the irrevocable trust. We're going to take it back out of the trust because you did it with the intention of defrauding creditors.
Right. So I thought you put stuff in your trust so that you can hide your assets. So you really can't hide your assets.
Yeah, you can, but not with a revocable trust.
Yeah.
Now it does take the name out of it. Does take like a title to the property out of your name, and it puts it in the name of the trust. So somebody's going to have to do a little bit deeper dive to find out who really is the beneficial owner of the property, because your name is not going to pop up. It's going to be your name as trustee of the trust.
If you put anything in the irrevocable trust, you cannot sell. You can't do anything with it.
Unless it's set forth in the directions of your trust.
After I die.
Pardon me?
After death.
After death, it's going to be up to the directions that you've set forth in your trust, or the authority of who you've appointed as the successor trustee. And you can describe that in your intentions, like if you desire that this business be kept in your family, you want them, or the real estate be kept in your family. I desire that this be kept in the family, and decide who's going to keep it. So those decisions will be made by the trustee, since you're not the successor trustee, since you're no longer there to make them. Unless you specify directions in the trust agreement that says this money is going to be used for this purpose, to provide for the education of my children, and then it's going to be distributed to them. So you can provide specific directions as much as you want as to how those are going to be distributed.
Something like confused me regarding the irrevocable trust. You have to have like bank account set up for the money if it's like the real estate, pay taxes on it, right?
Mm-hmm. The irrevocable trust owns the property at that point, and it will pay the taxes, and it will have its own taxpayer identification number, and it will file its own 1041 income tax return.
So who's managing this? Like, is it me? I'm paying those taxes? Like
the trust is paying the taxes, but
who's the person person who's doing it? Like, who's filing all this payment or like
that
sending the check to the county? for example?
that independent trustee that you appointed, whether it be your brother or a banker or somebody. You can have your CPA do it. Somebody you trust, but it helps if they share your Islamic belief.
Thank you.
And sometimes you don't trust one person to do that. You can appoint 3 trustees and say the decision 2 out of 3 are going to do it. And yes.
Yeah, I just want to ask, like, just now in your talk, you talked about like for calculating Sharia compliant share of your inheritance.
I'm sorry, I couldn't understand you.
Just now in your talk, you talked about one software, right?
Talk about what?
Heritage software, which will.
Software,
Yeah, what's the name of it? Because I couldn't find it, like,
IRTH?
IRTH, called Earth. But you can also Google Islamic Inheritance Software. Earth is the shorthand they use, but that kind of sticks in my mind. But and there are different providers of it, but the ones that I've seen are pretty easy to just input how many relatives you have and hit the calculate button. Now, I suppose it would be good to verify their calculations are correct, but it's a quick way to do it. And you can say, if I have 4 kids, it'll be this. If I have daughters, sons, it's this.
And one more thing I just want to ask is, like, as a take-home message, right now, if I go back to my home, I should take a pen and a paper and write down my will and sign it. That means this will be valid. This will be accepted, right?
I would like to see you have it typed out and witness your signature. The thing when you start typing it out, then it comes into the formal will, and then you have to have the formal execution of the will before 2 witnesses and a notary. Now, that problem alone is going to keep a lot of people from even getting a will. Where am I going to get 2 witnesses and a notary? I got to go do all that. I'm not going to do it. I'm going to do it tomorrow, next year. So the handwritten, the holographic will, it's all got to be in handwriting. You can put a date on it and who you want to get what, and then sign it. And it does not have to go through those formalities. And that's the bare bones minimum, okay? But that complies. That covers you as far as the 2 or 3 days to have your will for Sharia. But that's a starting point, and then you want to formalize it as soon as you can. So you have the more directions you can put in that will, the less questions there are going to be. And you don't want some judge coming in here and determining what Sharia is, even though it's enforceable. You want to appoint a personal representative that's knowledgeable about Sharia, and then you're going to say that personal representative is going to be responsible for interpreting this will or any disputes regarding it.
So a few of the people have question about the rough cost.
What?
Rough cost to establish a trust and, legal fees.
I don't speak for other attorneys. I don't know what they charge, and I don't want to know. But basically, I prefer to do the wills. I prefer to do the will and see. The will in a trust, it's fixed document, but at the same time, it requires a lot of conversation, and the conversation to me has to be open. And I don't believe in oh, it's the phone call. We talked for 30 seconds about a real 15 minutes or whatever. But so I don't bill by the hour. I bill by the project. And that way you don't hesitate to call me and say, I'm going to call Rex and ask him what should I do here. Because I'm not going to call him because he's going to charge me $100. But if I do it by the project, then you can call me whenever you want, which is what I encourage because it's a joint project. But to answer your question, typically for a normal husband and wife, and a revocable trust, it's less than $1,000, okay? But then to the extent you get to start getting LLCs involved, you start getting irrevocable trusts involved, we're going to get to start preparing a bunch of deeds and things, assignments of membership interests. Those may be an additional charge per document. So that's kind of a rough guess. Now, don't go to your attorney and say, you said you'd do it for $1,000 because they may do it, they may charge 10,000 or they may charge, I don't know what people charge. That's just the way I do it. I can't say what anybody else does.
Right.
So that's where the handwrite.
No, that's not the best way. That's just a way, a minimal way to do it. A minimal way to do it. But you have those requirements in, but at least do that. At least then you're compliant with. I mean, that's the first thing.
Yes.
That's the most important thing. Okay.
So just, can I ask a question right quick? So we're looking at about $1,000 to have a basic will drawn up and have it signed by two witnesses and everything else. And then, is that what the understanding is?
Yeah, a will for you and your wife.
Yeah.
That's 2 wills, one each,
Yeah.
and a revocable trust agreement.
Okay, now, is there any requirement to have that will registered somewhere, like in the county or the state or anything like that?
No. Now, we talked about that, because the will doesn't own any assets. Now, when the will gets probated, then it's required to be filed with the probate court. But if the will's never probated, which is the objective, then it's never filed with probate court, and only the trust determines how the distributions go.
So I assume that you have this going on there somewhere, right?
No. I didn't even put my address on this paper, but I'll tell you what, if on this thing up here, where it has my name, you can email me, and it's just put my name, Rex Hodges, no dot, no space, rexhodges@gmail.com. Or I plan on updating this after our conversation, because there's so many questions I'm going to keep. Every time we talk, I want to update it. There's so many questions. There's so much.
So any other question, please? Jazakumullah alfa khair, all of you. May Allah subhanahu wa ta'ala help us in making right decisions. We will have some snacks, and prayer time is 4:45. So I will request, please hang on, pray with the Jama, and let's have some snacks.
Are we gonna have any follow-up on this meeting? Anything?
Follow up.
Yeah.
What follow up you need?
Follow me, says, if we invite gentlemen again. and
We
have-
can. Rex has been so nice. He has accommodated our schedule. We can invite him again for sure.
Well, what I would like to do, I mentioned that there's going to be a scholar here next Friday.
Yeah.
I would like to come listen to that. And what I would like to do too is if you like to have more discussions about specifics or different matters, I'm glad to come. I enjoy it. I learn, like I say, I learn more from you than you do from me. So I appreciate being invited anytime.
Thank you.
Well, thank you. It's an honor to be here. I appreciate you all so much.
Jazakallah khair. Thank you so much, Rex, again. Let's eat something.
Yes.
I think they have.